Okay, the next case we'll take up will be Brown versus School Board of Putnam County. You got 40 minutes in you?
What's that?
You got 40 minutes in you, not just 20?
Sure.
Oh, no.
Actually, thank you for letting us do this, having these cases travel together. I think it makes a great deal more sense. May it please the court, I'm still Bruce Hanna, and we still represent Brown & Brown. In this case, Brown & Brown is again the appellant, but it was the plaintiff below. Following the entry of the Hamilton County verdict, Brown & Brown went to its actual contractual partner, NEFAC, and sought indemnification under 6.1 of the administrative agreement between them.
Is this action moot if you prevail on your first, the argument we just had before?
No.
You're going to seek attorney's fees
and costs and things like that should not have been incurred. Brown & Brown files its complaint seeking indemnification against NEFAC. NEFAC answers, asserts some affirmative defenses. Brown & Brown challenges those affirmative defenses via motion to strike. NEFAC files a motion for summary judgment. The court decides that if it hears the motion for summary judgment and grants it, that would moot Brown & Brown's motion to strike the affirmative defenses as legally deficient. The trial court did grant the motion for summary judgment, finding that Brown & Brown was negligent, that it had acted contrary to something called the plan, and that it was barred from being indemnified by virtue of its wrongful act. The indemnity contract between NEFAC and Brown & Brown states that NEFAC will indemnify Brown & Brown for any losses arising out of the performance of its contract, except if Brown & Brown is negligent or if Brown & Brown acts contrary to the plan. And so with those three findings by the trial court, which I'll try to address individually, the trial court ruled that Brown & Brown was not entitled to indemnity.
Let me ask you this. In the GenCorp case, we stated, this was 2008, that Florida law disfavors agreements to indemnify parties against their own wrongful acts, and that such agreements are not enforceable in the absence of a clear and unequivocal contractual expression of such an intent. So let me break that into two parts. First of all, did the jury find that your client had performed a wrongful act?
A breach of contract can be characterized as a wrongful act.
Right. And would you agree here that we have a wrongful act then, according to the jury?
Yes, there is a breach of contract.
All right. So where in the agreement with Putnam County and your client is there a clear contractual expression of an intent to indemnify Brown & Brown even against their own wrongful act? I mean, can you point out a provision where it has that intent expressed?
If I'm recalling the facts of GenCorp correctly, two claims went to jury trial. The breach of contract claim, which the court ultimately entered judgment on, and a negligence claim where there was a finding of negligence, but judgment was not entered on it. And in that case, this court had the benefit of a jury determination that there was negligence.
Well, I'm leaving out, I understand your argument that negligence is not the same as a breach of contract.
Right.
But if your client's breach of contract was a wrongful act, then I'm asking you to point out a provision in Brown & Brown's agreement which evinces a clear and unequivocal contractual expression of an intent to indemnify even against one's own wrongful acts.
Right, and there is no clear and express provision of the indemnity agreement that says Brown & Brown is to be indemnified for its own wrongful acts. I guess 2 points that I would raise in connection with that are that although many courts use the phrase wrongful acts in describing a variety of events, as far as I know, there's no body of law that says a wrongful act disassociated from any finding of negligence results in the inability to be indemnified. And I think if we look at this particular contract, it promises to indemnify Brown & Brown if something goes south in Brown & Brown's performance of the contract. If something goes south in the performance of Brown & Brown's contract, somebody somewhere is going to say Brown & Brown breached this contract by not performing correctly under it. If that's the case, then this indemnity agreement means nothing, because the only time Brown & Brown would ever seek to invoke it is if it sustained a loss as a result of the performance of his contract, which is exactly.
It could apply if Brown & Brown was vicariously liable for the wrongful acts of someone else, and then they get hit with a judgment, and then under this agreement they could, get indemnity.
Right.
But this isn't a case of vicarious liability. So that provision would apply in case of vicarious liability, so it would mean something.
I guess is kind of brings us to the fact that, as you know from reading the briefs, that Brown & Brown's position is that, of course it was held liable for breaching contract in the Hamilton County case, but in terms of trying to figure out how and why that happened, there are a number of facts that need to be determined. If a jury in a negligence case finds that Brown & Brown acted with reasonable care, notwithstanding that it ultimately failed to perform its contract, Brown & Brown would be found to be not negligent. And the facts that are set forth in the brief are that Brown & Brown was found by the Hamilton County not to provide certain information to ACE, and specifically the ACE representative at trial said there were two things. It should have been told the first date of the dialysis of the subject employee, and it should have been told the last date of that employee's employment, and it wasn't. The testimony at trial was that Brown & Brown was only required to disclose that first date of dialysis if it occurred before April 1st of 2002. A separate third-party administrator named Fringe Benefits processed claims for an effect. Fringe Benefits maintained throughout the entire insurance application process that the first date of Mr. Hargreaves' dialysis was April 12th of 2002, obviously a date subsequent to April 1st, and therefore it would not have needed to be disclosed, according to the ACE representative. In fact, after the application process was complete, everyone discovered that the first date of dialysis was February 2nd, a date that did need to be disclosed. Absolutely, Brown & Brown did not pass that information along to ACE and could have been found by the Hamilton County jury to have breached its contract. Nevertheless, the question for a trial in the NEFAC case is, did Brown & Brown reasonably rely on its contractual partner, Fringe Benefits, to provide it with accurate and timely information to pass along to ACE? And I think that's a very long way of getting to answering back to your question, which is Brown & Brown certainly breached a contract, but if it's only being held liable for breaching a contract because its contractual partners who it reasonably relied on to provide that information failed to get it to them, then this case starts looking an awful lot like the Hiller case cited in our brief, which is, I'm sure you recall, the one where the marina sold bad fuel to its customers. They sued it. The marina then sued the entity who provided the bad fuel, and the person who brokered the deal between the marina and the bad fuel provider. Summary judgment, let me see. In response to the claim by the marina, the broker filed a claim for indemnity against the actual provider of the bad fuel. Summary judgment was entered against Hiller on that claim. But the district court said, wait, that's not right. Hiller's being held liable solely for the wrongdoing of another. And notwithstanding that Hiller had been sued on breach of contract, much as Brown & Brown has been sued on breach of contract here, Hiller was allowed to pursue his indemnity claim against the provider of the bad fuel. Similarly, the other bit of information that the insurance company used to deny coverage was they didn't know the last date of Mr. Hargrett's employment. In Section 4.1 of the administrative agreement, NEFAC promises to tell Brown & Brown of any change in an employee's eligibility status. The system involves school districts filling out these things called change cards when an employee's employment status changes. Fringe Benefits enters that information into the claims-paying computer system. Hamilton County, in this case, filled out a change card saying that Mr. Hargrett retired on March 28th of 2002. If that's true, according to ACE's representative, that didn't need to be disclosed to ACE. No retirement needed to be disclosed to ACE. During the application period, Hamilton County failed to advise NEFAC, therefore making it impossible for NEFAC to discharge its contractual duty to Brown & Brown, that in fact Mr. Hargrett had become disabled from working and wasn't actually retired.
Could the jury have returned the verdict they did in the underlying case if the jury had not found that your client had at least in some way contributed to the lack of coverage by not correctly performing?
I think so, Your Honor. I think they could have found a breach of contract because I think the jury could have said, here's the administrative agreement. It says Brown & Brown has to get this information into the hands of the insurance company. Brown & Brown failed to do it regardless of the reason. It therefore breached that contract.
But wasn't your defense at trial that we didn't do anything wrong, someone else did?
Yeah, Debbie Maycomber testified that she actually did get sufficient information to ACE, but the idea of exercising...
The jury rejected that, didn't they?
What's that?
Didn't the jury reject that defense?
I don't think they necessarily rejected it. I think there's no place to plug it into a breach of contract analysis because the exercise of reasonable care really isn't a defense to breach of contract action.
Are you saying there's some sort of strict liability?
I'm saying that, yes, in terms of the underlying action, I think the only question is...
Was the jury instructed in that regard?
They were asked solely whether they find that Brown & Brown breached a contract to Hamilton County by failing to submit or complete and submit paperwork. That was the question to the jury. And so that's a yes-no question. And there's nothing in there, nor could there be in a breach of contract action that said, if you find that even though Brown & Brown really didn't do it, they exercised reasonable care, your finding should be for the defendant. That's just not part, obviously, of a contract action. As far as... And
where did the wrong paperwork come from? From Hamilton County, right?
What's that?
The wrong paperwork, if you would. If your client was provided incorrect information and passed it on, that wrong information would have come from Hamilton County, correct?
Yeah, I guess it would have gone from Hamilton County to NEFAC.
And Hamilton County is the plaintiff. So if it was all their fault, I have a hard time believing that the jury wouldn't have been instructed in some way that if you find this was all the plaintiff's fault, then they're not entitled to recover money.
I don't think the jury necessarily had to consider the reasons behind it, but only the fact that the information wasn't turned into to ACE. I'm not sure contributory negligence, I mean, you couldn't do comparative negligence in a breach of contract case, and a prior breach kind of argument, we didn't have a contract.
Well, but if Hamilton County was the plaintiff, and Hamilton County was the one fully and solely responsible for the failure to get the proper paperwork to ACE, I just have a hard time believing that the jury wouldn't have been instructed in some way that if you find that, then Brown & Brown is not liable.
There was no such instruction, and although I talked about the last date of employment second.
Then what was the purpose of the defense to put out all these witnesses to say it wasn't Brown and Brown's fault?
I suppose it was relevant to helping to explain how the system worked. It was optimistic that the jury might take into consideration that Brown and Brown's contractual partners let it down. But as a legal element to a defense, it doesn't plug into a jury verdict or into jury instructions for that matter. There's no point at which the judge instructed the jury that if they find Brown and Brown reasonably relied on its contractual partners, that they ought to find in Brown and Brown's favor. I know you know that the point of this appeal from Brown and Brown's perspective is the trial court's finding that Brown and Brown was negligent as a matter of law is erroneous because there are so many facts that need to be sorted out as to whether Brown and Brown exercised reasonable care under the circumstances. The trial court also found, and I'll only touch on this briefly, that Brown and Brown acted contrary to the plan and therefore was not entitled to indemnity. As I said in the brief, the plan document was never provided to the trial court. It was never entered into evidence by anybody, and the trial court never saw it. Finally, there's the trial court finding that Brown and Brown's wrongful act precludes it from being indemnified. There is no exception in the indemnity agreement that says, your wrongful act or your breach of contract with somebody else is also going to disqualify you from being indemnified. And as we've discussed, perhaps inside the vicarious liability arena, that indemnity agreement would mean something. But outside the vicarious liability, if that's true, if any shortcoming of Brown and Brown's ends up disqualifying it from being indemnified, it's not much of an indemnity agreement.
All right, you're at 3 minutes.
Thank you.
Yeah, it's again Dennis Shute for Hamilton County. I find it interesting that a defendant who at trial's corporate representative said, yes, our employee did not do the correct procedures, did not fill out the correct forms. Yes, as a result of that, insurance was denied. One of our indirect customers. Yes, as a result of that, that customer suffered $412,000 worth of damage because they had no insurance. But that isn't clear enough for summary judgment. I think those facts were the ones the judge relied upon primarily, is that the defendant came in and admitted fault. And now they want to back off that and say, no, there were disputed facts. The key one that they rely upon, amazingly.
Well, what were the disputed facts specifically as to negligence?
I know of none. But based upon the testimony of their corporate rep, there were no disputed facts as to negligence. They admitted that we screwed up. They were supposed to put down on the form that Hargett had end-stage renal disease. They did not. The insurance company said that was critical. If we'd known that, the premiums would have been different. Because of that, we denied coverage. Now, the document they want to rely upon.
Did they take that position before trial?
Yes, sir. Yes, sir. In deposition, their corporate representative said that the main reason for their denial of coverage was the non-disclosure of Hargett. Because they said they would.
No, I'm sorry. Did Brown and Brown take the position before trial that they messed up, and as a result of their mess up, Hargett was not insured?
Not until their representative was called to the stand. And that, for the first time, when asked the question, was it your fault? For 3 or 4 years of litigation, they fought vigorously. They did nothing wrong. And then the court representative was put in front of a judge and 6 jurors admitted they did wrong. And now they want to say, well, wait, but then we get to file a summary judgment. Well, the interesting thing about that is that same contract we rely upon allows defect to pursue a claim for indemnity if they have to pay monies that are not their responsibility and are Brown & Brown's responsibility. So theoretically, we could turn around and counterclaim by defect in the suit, Putnam County specifically, for indemnity if Brown & Brown is successful against defect is successful against Brown & Brown, and it's a circle. And so it's absurd to think that Brown & Brown has any, and they didn't, by the way, identify any disputed facts except what they rely upon. Well, we didn't know to tell ACE about it until after the contract was already let. Well, in our brief, in our facts, we relate to the court the exact testimony that came out through Beth Leahy and was in the evidence. Debbie McCumber on April the 12th received a letter from NEFAC in response to a due diligence request, which contained a March 31st report showing Hargett renal failure. April 12th. She had no explanation for why she didn't pass that on. But they said, well, we never knew. Well, she knew. She knew as of April 12th. The policy wasn't issued until June the 12th. And the corporate representative, they said, hey, she had an obligation. First of all, let me back up. She had no obligation to tell us about anything that occurred after April 1st. But if she became knowledgeable of information that happened before April 1st, she had an obligation to tell us before June the 12th when the policy was issued. And if we'd had the information before June the 12th, we would not issue the policy in the same circumstances. Additionally, the information that Brown & Brown did not have. 11 different bills were sent to them prior to June 12th, which were processed for payment for renal failure. They had the first bill they paid on April 2nd, was on April 2nd. They paid the bill where the code was 585, renal failure. Beth Leahy testified, I'm just a pass-through. I have a computer. We input, the doctor's bill comes to us. We input the doctor's bill into the computer. It goes, it's the same computer system Brown & Brown has. That information is instantly available to Brown & Brown. On April the 2nd, that bill was paid by Brown & Brown based on information put in by Beth Leahy prior to that. And it's somewhat disingenuous for them to say, well, because Beth Leahy filled out a report on July 27th, 2002, 6 weeks after the policy is issued, because she put on the report an incorrect dialysis date, that's the first we knew of it. First we knew of it. Well, that belies all the evidence. That's just an affront to the entire system for them to come in and say, no, we didn't know all that, when in fact they paid a bill for it. If the court looks carefully at pages 7 through 9 of our facts statement, I go through in great detail the breakdown. There were bills paid prior to June the 12th, in which Debbie McCumber never told ACE, oh, by the way, we have this problem. So for them to say that there were issues of fact, there were none. For them to sit there and say, folks, NEFAC, we get to sue NEFAC because our employees screwed up. Because it's not negligence they were sued upon. It was their failure to perform under a contract. And therefore, the failure to perform under a contract, that's not covered. So yeah, we cost Hamilton County $400,000, but, we have a way out of that. We don't have to pay that, even though our employees admit to it. And that's offensive. And so the court should not consider the arguments by Brown and Brown on the granting of the summary judgment. What they would have the court do, what they would have the lower court do, is go back and reinvent the wheel. Talk about lack of judicial economy. Let's go back and put every witness back on the stand. Let's go back and have all the information determined, when in fact the interpretation of the contract is up to the judge. And I think the court was absolutely correct in citing this court's language, saying that Florida is very strict. If you want to say, okay, I want to be protected from my own screw-ups, I want you to pay it even if I'm wrong, that language has to be absolutely abundantly clear. To suggest, as counsel does, that implicitly, because the only way that they could be sued is because they've done something wrong, implicitly that NEFAC would understand that and understand, well, we're here to help, but if we screw up, you're here to pay. And that's just wrong. That's just a wrong application of the law. It's a wrong application of facts. And we would ask the court to find in favor of NEFAC and support the granting of the motions for summary judgment.
Let me ask you one question.
Yes.
To the extent that the trial court held that Brown and Brown was not entitled to indemnification because the actions were contrary to the terms of the plan, what is your response or comment regarding the fact that the suit was about the administrative agreement? And I've heard that the plan itself was never, actually there's no indication it was ever seen or considered by the trial court.
Actually, if you read the language about the plan was the method in which payments would be made and the type of payments, the type of conditions that would be paid for. For instance, if you have a pre-existing condition, we're not going to pay for it. All the typical insurance policies. The plan is simply Brown and Brown's guidelines for how to pay the bills, and Brown and Brown's instructions on what bills they'll pay and how they'll pay them. So the plan is a red herring. It's something that is not significant here. It's the requirement in the administrative service agreement that they properly perform their underwriting responsibilities. And that's what protects, because NEFAC doesn't have that ability. NEFAC doesn't have insurance scholars on their staff to say, okay, let's make sure we know how to fill out this form. That's why they pay the price and pay the hefty price to have Brown and Brown incur that responsibility. So Brown and Brown has the responsibility, Brown and Brown fails to perform the responsibility, and Brown and Brown says, well, but you agreed that if we screwed up, you'd pay for it. And I just don't think that that is the way the law is. So the plan is insignificant, because all it tells is the obligations that how an employee, when they're sick in Hamilton County, submits their bill, what bills they can submit. For instance, there's no dental coverage, so you can't submit dental bills. You can submit bills when you go to your doctor, as long as you stay within the plan, so to speak. It's just your typical health insurance policy is what it is. No further questions?
All right, thank you.
The discussion we just heard on the plan is just wrong. It's not internal Brown and Brown guidelines. Even if it were, there's no record evidence that it was. The administrative agreement says what the plan is. The plan includes definitions of benefits payable, conditions applicable to, or limiting payment of benefits, and persons entitled to benefits. None of that's addressed in the administrative agreement. It clearly references a second document.
I know that your defense here is that it wasn't a finding of negligence, it was a finding of breach of contract.
Correct.
Let me ask you this. They did prove a duty. They did prove a breach of that duty, and they did prove damages. Didn't they, before this jury, whether they returned the verdict on negligence or not, prove negligence?
No, sir.
Okay. What element is missing?
Well, the trial court never identified nor required NEFAC to identify what duty they said was breached here. We're assuming that the duty is just what you said it was, that Brown & Brown had a contractual duty to perform. There's no case in Florida that says a breach of contract equals negligence as a matter of law. If you go back to the body of law that existed before the economic loss rule, when people were trying this.
The body of law is, a matter of law, is whether or not there's any conflicting evidence from which you can find no negligence, isn't there?
There is.
If everything points to negligence, doesn't that establish it sufficient for summary judgment?
The question for negligence is whether or not Brown & Brown exercised reasonable care. Finding that Brown & Brown breached a contract just doesn't answer that question.
So if we had a follow-up indemnification action and they took your client's testimony that they gave at trial, did a motion for summary judgment and said, here's what their witnesses testified at trial, this negligence, I mean, why wouldn't that apply here?
There wasn't actually any subsequent deposition. We're all talking about the
Yeah, I'm just saying, if later on, if we reversed and allowed indemnification action to go through, why couldn't they just take your corporate representative's testimony and the other former employee's testimony, do a motion for summary judgment, attach their trial testimony, and say they were negligent?
Right. The characterization of that testimony is different than the actual testimony. The former Brown & Brown employee said she turned in a document to the ACE representative. But the point is, even if both went and said exactly what they said at the trial, we had to fill out this document and we didn't fill out this document. It's the additional question, why not? And is the answer to why something that goes to whether or not you exercise reasonable care?
Two possible answers, one intentional, the other negligent, right?
What's that?
There's two possible answers, negligence or intentional.
Or that they acted in reasonable reliance on their contractual partners. I did want to point out the GenCorp case that you had cited before. I saw after the sentence that you had read that it says GenCorp did not clearly and unequivocally express an intent to indemnify GenCorp against its own negligence, although the paragraph starts with the
Wrongful act.
phrase wrongdoing.
All right, thank you both.